This is the Station for Negotiation podcast, episode number 56. My name is Gene Killian. I've been a lawyer and professional negotiator for 40 years. One of my best friends in law school was a guy named Ronnie Sendukis, who passed away way too young. And I spent many nights with Ronnie late at night, having a few beers and arguing about anything and everything. Politics, sports, history, whether Texas was better than New Jersey and how. We would fight about anything. The great thing about Ronnie is when he was wrong, he would become more entrenched in his positions. But I remember one night we were arguing about something. I don't even remember what we were arguing about. I think it had something to do with baseball, probably. But I had read a statistic in the newspaper that afternoon that I thought was a great statistic to use to win this argument. And yes, we used to read newspapers, actual pieces of paper with print on them. That's how old I am. And I remember during this argument, I laid this statistic on Ronnie, and he looked at me and he said, there are three kinds of disinformation in this world: lies, freaking lies, and statistics. Now, he didn't say freaking, but this is a family show, so I'm going to keep it as freaking. And that's what I want to talk to you about today in an oblique way of introduction. I want to talk to you about the use of math and statistics in negotiation and how dangerous it can be. And to do that, I want to talk about one of the most tragic and unfair legal proceedings I've ever learned about. A trial, if you stop and think about it, in a court is basically a negotiation. You're negotiating with the jury to see things your way. You're negotiating with the judge to see things your way. And to a certain extent, you're even negotiating with your adversary to see things your way in the hope that at some point at a break in the trial, you can settle your case. But imagine a prosecutor telling a jury that the chance of a defendant being innocent in a criminal trial is 1 in 73 million. Well, back in the 1990s, that number, that statistic, helped convict a British lawyer named Sally Clark of murdering her 2 infant sons. But what if that number was completely wrong? And what if the mistake was not caused by fraud or by bias, but bad math? Today, I want to talk to you about some of the mathematical presentations in this horrible trial. And one of the things I'm going to talk to you about is something called the prosecutor's fallacy, which is one of the most dangerous statistical mistakes you can see in law, in science, and in negotiation. And I should start this conversation by saying math does not come easy to me. It never has. It's always been work for me. I've had to work harder to understand mathematical concepts than my friends and my opponents. But I found a book that I recently read that was very enlightening. It's called The Math of Life and Death by Dr. Kit Yates, Y-A-T-E-S, who's a math professor at the University of Bath in the UK. And Dr. Yates really makes math understandable in a variety of contexts. And he talks about this case that we're about to talk about in the book and points out and discusses the statistical mistakes that were made during this trial. So let's start by introducing the case. And the central figure in the case is, as I said, Sally Clark. Sally Clark was a British solicitor. She was married to another lawyer, and they lived in Cheshire, England. And tragedy struck their lives, unfortunately. Her first son, who was named Christopher, died suddenly in his crib in 1996 as an infant, which is terrible. Compounding that, they had a second son named Harry, and he also died in his crib 2 years later in 1998. And both deaths were initially classified as sudden infant death syndrome, or SIDS as it's known in the United States. I think in the UK they call it COT syndrome, C-O-T syndrome. Initially, this was just thought to be a terrible tragedy, but then suspicion started to grow. And the prosecutors, the prosecuting attorneys in this area of the country, decided that 2 unexplained infant deaths in the same family must be murder. There was no other alternative way of seeing it. And so they arrested Sally Clark. They initially arrested her husband too, but they let him go. They arrested Sally Clark and they charged her with the murder of her 2 sons. And the trial turned into a battle of experts. Now, if you're not a lawyer and you haven't spent time around courts, let me tell you what an expert is. An expert is someone who definitely wasn't there, but who will gladly tell you what happened if you pay him or her a handsome fee. And in this case, both sides had experts. And the defense argued that Christopher had died of a respiratory infection. That's the first son, which was noted in the autopsy report. The official autopsy report said that Christopher died of a respiratory infection. And the defense also argued that Harry, the second son, had died of natural causes. And later, much later, they learned that the causes were likely to be bacterial meningitis. The prosecutors, on the other hand, initially argued that Harry had been shaken to death, but they changed their story to say that he had been smothered to death later when the shaken to death theory didn't work out for them. And they basically argued that both of these children, these infants, Christopher and Harry, had been murdered by their mother. But it was obvious to the prosecution that with the conflicting medical and causation evidence, the jury was going to get lost in the weeds. So they decided to bring in a super expert witness. And this super expert witness was a pediatrician named Dr. Roy Meadow. Now, note, the guy, Dr. Meadow, was a pediatrician, not a statistician, not a mathematician. He was a pediatrician. And he testified at trial. And he testified that the probability of 2 SIDS deaths in the same affluent family was 1 in 73 million. And here's how he calculated that. He assumed that this family was in the lowest risk category for SIDS because affluent families, in his theory, are less likely to have SIDS deaths than families that are lower on the social or economic spectrum. And he said that the chance of 1 SIDS death is, in the UK at the time, in the 90s, was 1 in 8,500. And he then squared the number. He said that so the chances of Christopher dying of SIDS, 1 in 8,500. The chance of Harry dying of SIDS, also 1 in 8,500. So to figure out the probability that 2 kids could have died of SIDS, all we have to do is take 8,500 and multiply it by 8,500, and we come up with 73 million. So, according to Dr. Meadow's testimony, the chances that Sally Clark was innocent were 1 in 73 million. And that statistic, that 1 in 73 million statistic, dominated the trial. And as a result, in 1999, Sally Clark was convicted of double murder, and she was sentenced to life in prison, where she did not have an easy time of it because she was considered by the other inmates to be a child murderer. And as you may know, in any prison, there is a self-enforcement mechanism and a social strata, and the murderers of children are considered to be the lowest of the low. So she was abused and harassed by her fellow inmates. It was really quite terrible. The problem is that the math that Dr. Meadow used was dead wrong. Now let's go through a couple of the reasons why the math was so wrong. First of all, Dr. Meadow's calculation assumed independence. In other words, he assumed that the death of Christopher had nothing to do with the death of Harry. They were both completely independent and unrelated events. But the medical research says otherwise. First of all, male children are more likely to die of SIDS than female children. He didn't consider that. Second of all, medical research shows that if one child in a family dies of SIDS, the risk of another SIDS death in the same family increases. And so the 2 deaths here, Christopher and Harry were not independent. There were factors that were ignored by Dr. Meadow and the prosecution, and unfortunately, it sounds like also by the defense. These falsehoods or these inaccuracies were presented to the jury as given fact, when in fact, these were not independent events. The causes of Christopher's death increased the chances of Harry dying of the same causes. So they're not independent events. That's a major problem with Dr. Meadow's testimony. Another problem with Dr. Meadow's testimony is that the number he's using, 1 in 8,500, if you look at it, is dead wrong. Actually, in the general population, if we just look at an average or a mean, the chances of a child dying of SIDS in the 1990s in the UK was closer to 1 in 1,000. So his numbers were wildly wrong. And again, this assumption of independent events was also wildly wrong. The second problem, and a major problem with Dr. Meadow's testimony, is something called the prosecutor's fallacy. And under the prosecutor's fallacy, the problem with the prosecutor's fallacy is even if the number he's giving is correct, 1 in 73 million, it doesn't prove guilt. So let me pause for a second and explain the prosecutor's fallacy, because for me, this is where Dr. Meadow's math really goes off the rails. Imagine I tell you that the chance of flipping 10 heads in a row with a coin is about 1 in 1,000. Now suppose you walk into a room and see someone who has just flipped 10 heads in a row, which can happen. Does that mean that the probability that the coin is fair is only 1 in 1,000? Of course not. Someone, somewhere, is eventually going to flip 10 heads in a row. So the mistake here is confusing two different questions. The first question is, what is the probability of this event happening if everything is normal? 1 in 1,000 in the example I just gave. But the second question is kind of the reverse. It assumes the event has already happened, and it says, given that the event happened, what is the probability that something underhanded is going on? Those are not the same question. But in Sally Clark's trial, the jury effectively heard the statistic this way. 2 SIDS deaths in one family are so rare that the mother must be guilty. And that leap from a rare event to proof of guilt is the prosecutor's fallacy, especially since it doesn't take into consideration any other possible causes of the death. The number itself also was wrong. As I said, the UK SIDS rate in the 1990s was about 1 in 1,000. In his book, Dr. Yates talks about the prosecutor's fallacy, and here's a kind of the illustration he uses, basically. Suppose you have a crime committed in a city. Suppose it's murder. And suppose we know that the blood of the suspect has been found at the site. And suppose that blood is tested and it turns out to be a very rare blood type that only 10% of the population has. Now, a suspect gets arrested. I'm going to call him Fred. We'll call our suspect Fred. And the only basis for arresting Fred is that he has this rare blood type. There's no other evidence connecting him to the crime. But Fred gets arrested because he has this rare blood type. And the prosecution argues that since 90% of the population does not have this blood type, there's a 90% chance that Fred is guilty of this crime. I mean, you can see the illogic in that. Let's think about it for a second, even from a person who's bad at math as I am. Let's suppose it's a city of 100,000 people. If 10% of the population has this blood type, that means there's 10,000 people in this city, assuming the statistics are accurate, that have this blood type. So really, the chances of guilt are 10,000 to 1 at this point, not 90%. And that is the prosecutor's fallacy. And it was used here in this trial. Dr. Meadow conflated the two questions. Again, what's the probability of this event if everything is normal? He conflates that with the second question, which is, given that the event happened, what is the probability that something underhanded happened? Again, not the same question. The third problem, or a third problem, with Dr. Meadow's testimony is something called the ecological fallacy. And for this, I'm going to go to Dr. Yates's book. Dr. Yates writes, one type of ecological fallacy occurs when we make the unsophisticated assumption that a single statistic can characterize a diverse population. As an example, in the UK in 2010, women had an average life expectancy of 83 years. Men, however, had a life expectancy of just 79 years. The overall population life expectancy was 81 years. A simple example of an ecological fallacy would be to state that because the average life expectancy of females is higher than that of males, any randomly chosen female will live longer than any randomly chosen male. This fallacy has a special and appropriate name, a sweeping generalization. Another commonly seen and unsophisticated ecological fallacy based on increasing life expectancy is the statement, we are all living longer, which is so often reached for by lazy journalists. Not everyone will live longer than he or she might have expected to previously. Clearly, these are naive suggestions at best. And then Dr. Yates talks about the ecological fallacy in the context of Sally Clark's case. And he writes, the ecological fallacy that Dr. Meadow committed by pigeonholing the Clarks into a low-risk SIDS category made their two children's deaths seem far more suspect than if the higher population rate of SIDS had been used. But even to use the overall population rate of SIDS would be to commit an ecological fallacy. Arguably, though, the population level assumption is less partisan and therefore more appropriate to a situation in which a woman's liberty is on the line. The erroneous assumption of independent SIDS deaths made matters worse. Well, after she's convicted, there's an appeal. And the first appeal, the judges reject. And they say that the role of statistical evidence was insignificant in the case, and the jury could not possibly have been misled. And that's despite statements from the jurors that they had relied on the statistical evidence which the prosecution had placed front and center in the case. It's quite an amazing ruling. And in this ruling is a warning to you, my dear listener. A lot of people think they're going to go to court and get justice. Let's put it this way. When I graduated from law school in the 1980s, I thought the judge must be the smartest lawyer in the courtroom. But after practicing for a while, I learned that the judge was just an ordinary lawyer who happened to know the governor. And judges make lots of mistakes. So my warning to you is, settle your disputes if you can. Reach a negotiated resolution. Stay out of court if you can, because once you go to court or arbitration, you are handing your fate, your dispute, over to a third party who wasn't there, who's just going to guess at some things, and who is trying to get it right, but doesn't really care about you. There's no other way to put it. Doesn't know you, doesn't care about you. To the extent you can keep control over your problems, you should try to do that. Fortunately, though, Sally Clark's conviction eventually completely unraveled. After 3 years in jail, getting abused and hassled by other inmates for allegedly being a child killer, her defense lawyers came up with new medical evidence. And it looked like both children, based on the evidence, died of infections. So in 2003, There's another Court of Appeal ruling, and the Court of Appeal on the second appeal says the statistical testimony that Dr. Meadow presented was misleading, seriously misleading. That leads me to the next question, which is, how was this guy even allowed to testify about statistics when he wasn't a statistician? It's mind-bending. But the second piece of evidence that the Court of Appeal loudly cited was that the prosecution had intentionally withheld medical evidence showing that Harry had died of an infection. And based on this new information, or this information considered by the court in the second appeal, Sally Clark was exonerated after more than 3 years in prison. But at that point, her life had been ruined. The damage was severe. And she tried to seek solace, unfortunately, in the bottle. And she became an alcoholic. And sadly, alcoholism killed her in the year 2007. It's a terrible, terrible story. But what lessons can we take from this tragic story as negotiators? Well, numbers, right? Numbers are often thought to be clear evidence. Negotiators often assume if the data looks precise, it must be reliable. But precision is not the same thing as accuracy, right? So here's a few lessons to think about. First of all, numbers create false authority. I'll say it again. Numbers create false authority. Here, in this situation, the statistic of 1 in 73 million sounded scientific. Jurors trusted it. But as I think we've discussed, and as you can see in Dr. Yates' book, the underlying assumptions were severely flawed. In negotiation, you'll often see models, projections, damage calculations, financial forecasts. They can also create this same illusion of reliability. You can't accept it. You have to look into the reasons behind the numbers, and you have to consider whether the raw data is correct. You have to ask those questions. Let me talk about my wife, Joni, for a minute here. She will deny this, but she got banned, literally banned, from a car dealership in Nashville, Tennessee. They got so tired of negotiating with her. And one of her points was that the manufacturer's suggested retail price of a car is nonsense, utter nonsense. And you know what? It is utter nonsense. It's completely made up. So car ads and car dealers love to talk about the MSRP, the manufacturer's suggested retail price. It's a meaningless number. Joni was always more interested in what dealers call the tissue price, which is what did this dealer actually spend on the car, and how much is the dealer going to make on the car in profit when they sell the car. And that margin between what the dealership spent and what the dealership anticipates making in profit, that's where the negotiation has to take place. The negotiation is going to be how much is the dealer's actual profit going to be and what's fair. Well, the dealer in Nashville didn't like that at all. But that's an example of not accepting a made-up number. I'll give you an example from my own career. I was in a complex negotiation once, and it basically dealt with how much of a loss a particular insurance company was going to be allocated on a particular loss. I'm not going to go into the details. It was a complicated loss. But at one point, this particular insurance company offered to pay something like 39%. And I don't know why I said this, but the client was in the room with me, and I said to the other side, we have to have 42%. And the lawyer on the other side, who I've known for a while, was like, why? And I said, look, we've had our own calculations. I'm just telling you, we have to have 42% to sell this internally. Now, I don't know why I said that. And I'm going to say that there's a legal term for the argument I just made. It's called bullshit. I was trying to bluff my way to a higher number. I wouldn't do that again. I don't know why I did it in the moment, but I got the 42% for whatever reason. And I've often thought if they had asked me, show me the calculation that got you to 42%, my argument would have fallen apart and I would have ended up either with 39% or less. I don't recommend doing that. I'm just telling you that when someone starts throwing numbers around in a negotiation, be skeptical. Now, here's the correlation to that. Bad assumptions destroy good models. In Sally Clark's case, the entire calculation depended on one assumption, that Harry's death and Christopher's death were completely independent of each other. And we've now seen that's not true because there are statistics that show that if you have one Sid's death in a family, the next Sid's death is much more likely to happen. And we've seen that if it's a male baby, more likely to have a SIDS issue. So once the central assumption turns out to be wrong, Dr. Meadows' entire number collapses. And you're going to see this in complex negotiations involving risk modeling, financial projections, litigation exposure estimates, all this stuff that requires interpretation of data. You're going to see people playing games with numbers, right? And so you have to dive into those assumptions and tear them apart relentlessly. Always ask, what assumptions produced this number? A good negotiator interrogates data. So here are the questions you need to ask. Where did this number come from? What assumptions drove this number? What happens if I change the assumptions? These are the kinds of questions you need to ask. Another thing to keep in mind on this topic is always reassess. There's something called Bayesian reasoning, Bayesian reasoning in statistical analysis. And Bayesian thinking simply means always update your beliefs as new information comes in. Avoid tunnel vision, in other words. For example, imagine you heard a loud crash outside your house. Your first guess is somebody just dropped a trash can. That's the most common explanation. But then you look outside and you see smoke and flashing lights. You update your belief, right? Now, maybe it was a car accident. Each new piece of information changes the probability of different explanations, right? You always have to be alert to the fact that explanations may change. So in the Sally Clark case, the jury was given a dramatic statistic, 1 in 73 million. But they were never asked the key question, which is, given how many families there are in the country, and how often SIDS tragically occurs, how likely is it that 2 deaths could happen naturally in the same family? And when you ask the question that way and give the jury the proper evidence, the probability of innocence is much higher than the prosecution suggested. So in this case, this terrible Sally Clark story, a confident statistic, 1 in 73 million, helped persuade a jury that a grieving mother was a murderer. But numbers don't speak for themselves. They speak through the assumptions behind them, and also question the credibility and background of the person proposing the statistics. How can we rely on a number calculated by a person whose profession does not involve calculating numbers? This is a pediatrician, not a statistician. So there's a credibility issue. So remember this, if you remember nothing else from this episode. Whether you're negotiating a contract, evaluating risk, or sitting on a jury, one rule always applies. The quality of your decision is only as good as the quality of the information you're relying upon. Let me say that one more time because it's so important. The quality of your decision is only as good as the quality of the information you're relying on. Question that information. Question authority. Interrogate the data. And folks, that's all I have for you today on the Station for Negotiation. So this is Gene Killian once again signing off and reminding you that negotiation is life. Hey, thanks for listening to the Station for Negotiation podcast. Until next time, you can keep up with us on social media at the following places. On X, formerly known as Twitter, it's at STN4Negotiation. That's at STN4Negotiation. On Facebook, you can hit us up at facebook.com/Station4Negotiation pod. That's facebook.com/Station4Negotiation pod. Over on Instagram, you can reach us at Station4Negotiation. Again, that's at Station4Negotiation. On LinkedIn, Station4Negotiation podcast. Again, that's Station4Negotiation podcast. Over on YouTube, we're at Station4Negotiation. That's at Station4Negotiation. If you want to shoot us an email, you can do that at Station4Negotiationpod@gmail.com. That's Station4Negotiationpod@gmail.com. So we'll see you next time on the Station for Negotiation podcast. And until then, remember, negotiation is life.